In the UK, consumer rights are protected by a comprehensive framework of laws that ensure fair treatment when purchasing goods or services. Understanding these rights is essential for effectively handling disputes that may arise. As a consumer, your primary protection comes from the Consumer Rights Act 2015, which applies to all contracts for goods, services, and digital content. This legislation guarantees that products must be of satisfactory quality, fit for purpose, and as described. If these conditions are not met, you have the right to a refund, repair, or replacement. When a dispute occurs, the first step is to identify the nature of the problem. If you have purchased a product that is faulty or misrepresented, or a service that has not been performed to a reasonable standard, you should contact the seller or service provider as soon as possible. It is crucial to keep records of any communication, such as receipts, emails, or contracts, to support your claim. Legally, if a product develops a fault within 30 days of purchase, you are entitled to a full refund. After this period, you may still request a repair or replacement within 6 months, and the retailer must prove that the fault was not present at the time of sale. For services, if the work has not been completed with reasonable care and skill, you can ask for it to be redone or for a price reduction. When making a complaint, it is advisable to approach the business in writing. Clearly state the issue, provide evidence, and explain what resolution you expect, whether it is a refund, repair, or compensation. Be polite yet firm, and give them a reasonable time to respond. Many disputes can be resolved at this stage through direct negotiation. If the business agrees to your claim, ensure that you document the agreement and the timeframe for resolution. If the business refuses to acknowledge your rights or fails to resolve the issue, you can escalate the matter by seeking advice from a third party. Organizations such as Citizens Advice can provide guidance on how to proceed and may help mediate between you and the business. In some industries, you may also be able to use an alternative dispute resolution (ADR) service. ADR schemes involve an independent third party reviewing the dispute and proposing a resolution, which can be a faster and cheaper alternative to taking legal action. Ombudsman services are available for sectors like energy, telecommunications, and financial services, and they have the authority to investigate complaints and order remedies if necessary. If ADR or negotiations fail, you may need to consider taking the dispute to court. For smaller claims under £10,000, you can use the Small Claims Court, which is designed to be a straightforward and affordable way for consumers to pursue justice without the need for legal representation. Before filing a claim, it is important to send the business a formal letter before action, outlining your intention to take the matter to court if it is not resolved. This often prompts businesses to settle the dispute without further escalation. If the case proceeds, the small claims process is relatively informal, and you will need to present your evidence and make your case to a judge, who will then issue a ruling. It is worth noting that consumer rights extend to online purchases as well. When buying from a UK-based online retailer, you are protected by the same Consumer Rights Act, as well as additional regulations like the Consumer Contracts Regulations, which give you the right to cancel most goods and services bought online within 14 days of receiving them. This cooling-off period allows you to change your mind and receive a full refund, including any standard delivery charges. However, this right does not apply to certain types of purchases, such as bespoke or personalized goods. When dealing with international businesses or online marketplaces, consumer protection can be more complex. It is advisable to check whether the company you are buying from is based in the UK or the European Union, as EU consumer laws offer similar protections. If you encounter a dispute with a foreign seller, the first step is to check the terms and conditions of the sale to see what legal jurisdiction applies. While it can be more challenging to resolve disputes with international sellers, you can still seek advice from organisations like the UK European Consumer Centre, which assists with cross-border complaints within the EU. In some cases, businesses may attempt to mislead consumers about their rights. For example, they may claim that you need to contact the manufacturer directly for a repair, or that you have no right to return sale items. It is important to remember that your contract is with the retailer, not the manufacturer, and that the same consumer rights apply to items bought in a sale unless the fault was clearly pointed out at the time of purchase. Being aware of these potential pitfalls can help you avoid being unfairly denied your rights. In conclusion, handling consumer disputes effectively involves understanding your rights, keeping clear records, and approaching the business with a well-structured complaint. In most cases, disputes can be resolved through communication and negotiation, but if this fails, there are alternative avenues like ADR or the small claims court. By taking a methodical approach and knowing where to seek help, you can protect yourself and ensure that businesses are held accountable for the goods and services they provide.